Record in the matter 20 CV 55 State of Wisconsin versus Troy Lanning. The state appears through District Attorney James Reineke in person. Thomas Mulligan Sr. appears in person. Troy Lanning appears by video conferencing with approval of the court, and by requesting to appear by video instead of being in person. Mr. Mulligan, at the last hearing, you said that you would waive Mr. Lanning's appearance, but he is here today by video, and he is still okay to appear by video?
Yes.
Okay. All right, we are set today in this matter for the second hearing, or hearing in this case as it relates to the remitter from the Court of Appeals. And now we are here for the motion hearing for the forfeiture. I'm not certain if I received any additional follow-up writing, anything in writing. Who would like to argue or provide information to the court first?
The state would like to move to dismiss this case with prejudice.
All right, and basis to do so?
We believe that the complaint was improperly filed. We believe that the owner is actually the mother, Linda Horning, who is an innocent owner. At least we don't have any evidence that she is not.
When did she take ownership?
She took ownership apparently on June 1st, and the forfeiture wasn't started till June 11th. We also think that in the interest of justice that we do not want to proceed on this matter.
All right, and I can't recall, you did have a motion. I can't recall if you had a brief.
I don't remember at this point.
I don't think you had a brief. I'm just looking at a motion, and you have a little bit of facts and a little bit of analysis. Anything else you want me to consider, like any case law that says that the state can do something of this nature for a forfeiture after the fact? Any basis, any argument as to why the court should believe that this was not a fraudulent transfer with the allegations of criminal conduct that involve significant drug dealing and or intent to deliver when the occurrence date?
Right. There was drug dealing by the defendant, but we have no
17th, and then the transfer didn't occur until June 1st.
Correct. That having been said, we have no evidence that the mother was aware that this would be subject to a forfeiture, especially when the state didn't file it till June 11th.
Did she pay valuable consideration for the property?
We don't know one way or the other. However, there's also a case called Timms versus Indiana, which is at 139 Supreme Court, I believe, second at 682, talking about.
And that's what, Timms versus
Indiana.
Okay.
And that's basically says that it's unconstitutional for a taking if there's an excessive fines situation. And in this particular case, the criminal case was completed, but there was not a maximum penalty as a sentence. But in this case,
this involves our forfeitures as it relates to drug-related crimes, which is something that's completely different than excessive fines, where our statute is quite clear where it says where you have crimes that involve illegal substances, especially as it involves intent to deliver or dealing type cases.
That's true. Timms involved an automobile, but it was a $42,000 automobile. In this particular case, I think it's roughly a $44,000 property, in real estate. We just don't think it's right to proceed with this matter.
Do you have any case law that says that the court must follow or dismiss on basis of a prosecutor's motion?
I don't think it must, but I think it's one of the factors that the court can consider anyway.
All right, Mr. Mulligan, argument?
Well, we joined the argument by the state. In fact, I believe there was some discussion in the last hearing that the state, if it was compelled to go through a hearing, would not be calling any witnesses. And in that regard, there'd be no basis by which this matter could continue.
I don't recall that. Maybe it was said, but that's kind of saying that that the state's not going to do its job to try and put the court in the corner and say the court can't do anything because we don't want to do it.
There's no evidence, there's no conviction.
There's no evidence, there's no conviction.
In a hearing, if there's no evidence to support the case,
Then you're saying, do you understand policy and procedure? That means though that then the court can remove the state from not doing its job and get a special prosecutor in, and that makes it all mucky.
well, I think this case has got a share of muckiness, so.
I don't disagree. But I can't, I'm in a position where we all have to do our own jobs. We all have each independent jobs to do. We each wear separate hats. I can't just go, okay, the state's not going to do its job, so I'm dismissing it.
It's not that I'm not doing my job.
I'm just going off of what Mr. Mulligan just stated, what his statement was, and you weren't here at the last hearing. And I'm going to say, I don't recall that being said, but it could have been. I don't have a transcript. I'm just saying, give me case law other than because we want to. I can't recall either if I think you filed something. Maybe you did, maybe you didn't, Mr. Mulligan.
I don't, it's so old, I don't have a recollection.
So other than anything that's been put in writing, which I've read everything, I just don't recall off the top of my head. I was waiting for today to hear more arguments. Other than that, we don't have any other further arguments or case law or statutes to follow.
Well, there's general case law about an innocent owner, and we don't have any evidence that she's not.
We kind of do, because you don't have evidence to support that she is, because the allegations of the intent, the possession with intent, the dealing, the selling of the drugs occurred May 17th, 2020. Ownership wasn't transferred until June 1st, 2020. So obviously there was something there. We don't know if she paid a significant amount of money, any valuable consideration was paid. We don't know anything about any of this, other than it was transferred on June 1st, 2020 from Troy Lanning to his mother. And then the forfeiture action occurred on June 11th, 2023. And I understand the argument, Mr. Renicky, that you're stating that you're the district attorney, your assistant district attorney at the time filed the matter without your knowledge or authority to do so. I understand those arguments. I'm just asking for support for the arguments.
Trying to see if I can find something.
Anyone want to call anybody to provide any under oath testimony?
The burden is not on my side.
I'm kind of trying to join forces with the state.
Well,
Burden is on both sides, because if both sides are saying that both can get together, they can stipulate to a dismissal, and they can essentially force the court to do that. There needs to be something shown to me that that can occur, or otherwise it's in the court's discretion, and give me reason to go along with your arguments. All right, that's fine. What I'm going to do then is take this under advisement. Going to go back and reread any of the filings that have been prepared by both sides. I will listen to arguments, review notes from the previous hearings that we've had, and I will issue a written decision. The facts that I have are that the charges and offense dates, May 17th, 2020, transfer of ownership on June 1st, 2020, from defendant to his mother, forfeiture action filed June 11th, 2023. Those are the concrete facts that I have. Any other fact that I'm missing?
I think those are the essential facts. I tried to look up quickly on Westlaw to see if I could come up with a quick thing that I could find, and given the new computer thing, my passwords and other information aren't logged in, so I wasn't able to access it right now. But in the meantime, I'll try to look something up and shoot an email to the court with a copy to Mr. Mulligan.
That's fine. I don't need anything else. We're all good to go.
All right.
This is the hearing, and in fact, I think this is the third or fourth hearing we've had on this. Okay. All right. Well, I will get my decision out within 90 days.